I get this question a lot. Why should I make a will if a will requires you going through probate? Because that itself is very much misunderstood. I have people who come to me, they go, I'm not going to go through the probate process because I've made a valid will. I went to an attorney and everything, and look how beautiful this will is. And whether the attorney didn't tell them or they forgot, but I often have to be the bearer of bad news. Unfortunately, a will is still a one-way ticket to probate. But if you don't have a will, you operate under what's called the laws of intestacy. When you die intestate, that means you die without a will. And Florida law, Florida statutes dictate who gets your stuff, and they have a very specific order. So if you're okay going through the probate process, then you fill out a will, and the will, you can designate who you want to get your stuff and in what amount, and you can be very specific. Whereas if you don't have a will, you can't be specific at all. But better yet, you should have a will, but you should also have a revocable trust. Sometimes it's also called a living trust. Sometimes it's called a revocable living trust. But this is a trust that you would still own and control, and everything would be for your benefit. And you take your assets and you put it into this trust, and we can do so under the guidance of your elder law attorney. And now everything in the trust, because it's a living trust, stays right there. And after you pass away, things are owned by the trust and they're not owned by you. So you don't have to go through the probate process because your trustees have been given instructions on what to do with assets that have been placed into inside this trust. We also have things like ladybird deeds, and we can talk to you about how to set up your pay on death beneficiaries, and all these things can be done to avoid probate. But if you're only relying on your will, you are 100% going to probate court, assuming you have assets that will go through probate. We would prefer to see you avoid probate, and you would still have a will as sort of a safety net, right? We'd want to put as much as we can into this revocable trust, and the will is for anything, if you inherit something or that later on that you don't put into the trust, or you just forget to title some asset in the name of the trust, the will is there to capture all that. But if we can avoid relying on the will, in my mind, that is better estate plan. It's easier on your heirs. They don't have to go through the extra time and expense of going to the probate court the way they would if they were solely relying on that will. I hope this has helped you out and made things a little bit clearer.